(2018-510) State of Arkansas versus Michael Thomas Curtis.
Yes, sir, Your Honor. It's Michael Thomas Curtis.
Yes, sir. This case was set down for appearance here today. It's on our trial schedule for the week of July 15th.
You're setting it again, sir. I'm a U.S. Supreme Court Justice, F period, A period, K period, E period, Federal Association Klan executioner, Justice, Judge, executioner, a police officer. This is the fourth court docket, fourth court case. I've been in jail for 5 months with no charges. The charges were dropped on February 3rd, sir. You will release me today. I am a king out of the House of Names, this UK, out of England, Ireland, and Italy, and I am not guilty. Our charges were dropped February 3rd. There's only a $50,000 bail. I dropped the bail, gavel, and I released myself with your judge's name, gavel, which is a court law. Your Honor, you can see that there is no charges on my list. The felony was dropped, and the protection orders against my wife and my daughter that you fraudulently made up. All charges were dropped February 3rd, 2019, and I've been in jail 2 months and 5 months without being released. We've been trying to get me out of here. Are you murdering me,
Mr.
sir?
Curtis, I'm going to interrupt you.
Sir,
I've listened to you. Now,
this is my fourth push ahead. You have pushed me ahead 4 times now. This is my fourth court case. If you do not release me, sir, you will be fired and sentenced to life in federal prison. Gavel. Unstrikable gavel. I do outrank you in the court of law, and you have lost your job if you do not release me. Gavel. Do you understand me, sir? I am your boss. I am an undercover, off-payroll justice and judge. You will be fired for breaking the law with me, sir. Do you understand the charges of international and
Mr.
felony?
Curtis.
I am an Illuminati international judge also, sir. Do you understand me? You will lose your job and go to jail. At the end of the court date, you will be arrested.
Mr. Curtis, I don't understand you at all, and I've heard enough.
Do you understand me that I'm
If
your
you would
boss?
please remove the defendant.
Court's adjourned. Gavel.
2018-524, State of Arkansas versus Robert Lambert.
Yes, good morning.
Good morning. Mr. Lambert, do you have counsel? Yeah, public defender's office.
Just one
This is
moment, Your Honor.
another time the case is set on the trial schedule for the week of July 15th.
Your Honor, in visiting Mr. Lambert yesterday, I think the only issue today would be a bond reduction. The state has agreed that his bond would be lowered to the sum of $3,500, and subject to the usual stipulations that a bond is set.
Where is this bond set at this time?
It's at 50, Your Honor. There were some extenuating circumstances that have been addressed, Your Honor, and so the bond does not need to be at that level at this time any longer, Your Honor.
So what's the agreement is to
$3,500.
$3,500? All right. Bond to be set at $3,500, cash or professional. Mr. Lambert, if you make that bond, you are under an obligation to get in to see your attorney, Mr. Cooper. You do that by calling the public defender's office as soon as you're released and making an appointment and then keeping that appointment. And the court is ordering you to do that. So make sure you stay in touch with your attorney. That'll
Yes,
be the
sir.
order
Thank
of the
you.
court. You may be excused at this time.
Thank you.
2019-2, State of Arkansas versus Robert Chapman.
Your Honor, I think this is on the July 15 docket, the trial docket. In visiting with him yesterday, Your Honor, I discussed with him the plea offer that had been made. Your Honor, if we could have him come back on May the 2nd, there are some issues that came up that I need to discuss with Mr. Etheridge that he made me aware of yesterday. But there would be no further action to take today in Mr. Chapman's case.
All right, I'm putting him down to reappear on May 2nd. You may be excused, sir.
Thanks.
Two 2019-122, State of Arkansas versus Luke Tidwell.
Good morning, sir.
Good morning. All right, Mr. Tidwell, you're on this before this court this morning for arraignment on charges of 4 counts of forgery, each one a Class C felony, and theft of property, a Class A misdemeanor. Have you made an application to the Public Defender's Office, or are you represented by an attorney in any form?
Yes, sir.
Mr.
I made an
Cooper?
application to the public defenders. I talked to him yesterday.
He did talk to me, Judge. We talked about the revocation. I don't think he has applied on the new charge yet, Judge. Or the revocation.
Apparently, the Public Defender's Office doesn't have your application. When did you
Well,
submit it?
It should be up here at the jail. Like, they sent it back to me because I didn't fill it out correctly, but I filled it out all the way like last week, and I sent it back like Monday last week. They should have it by now.
Well, all right. Well, you're here for arraignment at this time. What I'm going to suggest is you fill one out and turn it in again. Apparently, it has not gotten to the Public Defender's Office. On the charges, I read off of 4 counts of forgery, a Class C felony, and 1 count of theft of property, a Class A misdemeanor. On those charges, I'll enter a plea of not guilty on your behalf. And we'll set this down. So I'm going to set you down to reappear on May 2nd, so that I can make sure that you've got counsel appointed. Your bond is listed at $2,500, cash or surety.
You know, there'll be a revocation following this one also, Your Honor.
Has a revocation actually been filed?
It's now happening, Your Honor.
I see. So it's not listed.
No, sir.
Okay. As of this moment, then, your bond status is you have a $2,500 cash or surety bond.
All right.
All right. You may be excused. 2019-134, State of Arkansas versus Chase Pollard. There's also 2019-136 involving the same defendant.
Should be Chad.
I apologize, it's Chad. The second one is Chad. So this is Chase Pollard.
Yes, sir.
All right.
Do you need my brother,
No,
sir?
no, not at this time. I just misread it.
Okay.
All right, Mr. Pollard.
He has applied, Your Honor. Both he and his brother have applied.
Has he been approved, or do I need to do that?
They have been approved, Judge.
Oh, they've been approved,
Yes.
all right. All right, so you're represented by the Public Defender's Office. This case is for arraignment today on charge of fleeing, a felony, Class D felony, reckless driving, and apparently a fleeing on foot, Class C misdemeanor, and careless and prohibited driving, a violation. On those charges, how does Chase Pollard plead?
Your Honor, he enters a plea of not guilty to all the charges.
Plea of not guilty is noted on the record. This case is on the Division 4 docket. I'm setting it, this date, I'm setting it for trial the week of September 16th with a reappearance on July 11th. Any other matters to come before the court at this time?
Your Honor, when I visited with Chase and Chad, they indicated that they could make a bond of $2,500. The state has agreed that their bond would be lowered from $10,000 to $5,000 for each of the pollards.
Your Honor, if they do make that bond, it's imperative to the state that we know where to relocate to. These are both individuals from out of state, don't have any connections to the state of Arkansas. Again, we understand the court's situation with bonding, but we just want to make sure we know where they're at so they will reappear.
Where are they from?
You know, we believe they're state of Texas, Your Honor.
Well, I guess I should discuss this with counsel at some point, but we've had such a flurry of these high-speed chases, and it's such an irresponsible and frighteningly dangerous activity as far as this court's concerned. I'm not sure I'm very agreeable to reducing the bond on this. It's not because they're from Texas, which would make, we should have a higher bond on somebody who's from out of state than on one who's from local, but my concern is we've had so many, or at least I've reviewed so many affidavits recently with these extremely high-speed chases that it causes the court a great deal of concern for the safety of the public. And I'm
Your Honor, I understand that, but I wasn't driving the vehicle, and
This,
I wasn't
Your Honor,
fleeing on foot.
just one second, Mr. Pollard. Your Honor, when I
Yes.
visited with both he and his brother yesterday, I know this is not the time to argue the facts of the case, but that is what he told me. I would rather say that than him say that, that neither he nor his brother were driving the vehicle in question. They also provided to me an address of 334 Maple Leaf Trail in Mountain Home as being their address. And checking our application, that is the same address that they gave on the application, same address they gave me yesterday. So I think they do have a definite Mountain Home connection. So
well.
I understand the court's concern, but I just wanted to point out.
All right. If that's the agreement of the parties, the court will reduce the bond to $2,500. But I guess I want everybody on notice that the court's bond is designed to ensure people appear, but it's also designed to make sure that we're doing all we can do to protect the safety of the public. And somebody who would flee in these high-speed chases from law enforcement, that is such a dangerous and irresponsible behavior that I think that we might look at setting higher bonds. I don't know. I'm just really I'm really concerned about it. But I will agree to the agreement of these parties. You all know more about the facts of the case than I do, obviously, coming across it the first time. So I will agree to the reduction of bond to $2,500, cash or professional. All right? You may be excused, sir. (2019-136) State of Arkansas versus Chad Pollard. I understand Mr. Pollard has applied to the Public Defender's Office as well.
He has, Judge.
And been appointed.
He has, Judge.
All right.
You know, the state's position is a little different with him since he was the driver. And we would like and I appreciate Mr. Cooper, I know Mr. Cooper tells us what he knows, but we would also like to verify an address from him because all the information we had was the Crosby, Texas address.
On the charges, which are fleeing, the felony fleeing, reckless driving, misdemeanor fleeing, and careless and prohibited driving, how does the defendant now plead?
Not guilty, Your Honor.
I know the plea of not guilty. The case is set on my docket, so it'll be set for trial during the week of September 16th with a reappearance on July 11th. All that goes into the scheduling order. And now we'll take up the issue of bond on this one.
Your Honor, again, as in his brother's case, he gave me the Maple Leaf Trail address, the 334 Maple Leaf Trail address yesterday, and looking at his application, that is exactly the same address that he filled out when he applied for our services. Your Honor, again, I know it's not the time to argue guilt or innocence, but both he and his brother told me that they were not the drivers of the vehicle, so I respect what Ms.
Was there a
Redford.
third person in the vehicle?
According to them, yes, Judge.
Your Honor, there's nothing in law enforcement's investigation that indicates that they were the only two in the vehicle. Based on his brother's statement, we have to assume that he was the driver.
Your Honor, they both told me yesterday that there was a third party. So it's very early on in the case, and again, I know it's not the day to talk about guilt or innocence, but I'm relaying to you what they relayed to me.
Your Honor, I appreciate Mr. Cooper's position. Based on all the statements given to us by law enforcement, this case was transpiring, and I have been involved in this one. There was apparently no room for another person in that vehicle except the two people who we have arrested. Your Honor.
That's what I thought I'd read in the affidavit as I quickly skimmed it, trying to get familiar with the facts of the case.
Your Honor, I told, while the court's considering bond, I told both of the Pollards yesterday that since their case arose from the same incident, that I would not be able to represent both of them. And talking to Amy of our office, Chad was arraigned first, and I'm so Chase will know, Mr. Pastings will now take over from this point forward. He'll still be represented by our office, just not by me. But I have no problem representing him today and arguing bond.
Now, this does set up a conflict situation by apparently both claiming to not be driving. I'm going to note on the record that Chase Pollard will be represented by Sam Pasting. Chad Pollard will be represented by Mr. Cooper. I'm not agreeing to reduce the bond on Chad Pollard, so his bond will stay at $10,000 cash or surety. So that's the decision of the court. Mr. Pollard, you may be excused.
Thanks.
Do we have a returned warrant in the Uriah Jones case?
We've not seen it come back. We were asked Tara when Tara said she's not got it back yet either, Your Honor. He has been 8.1 though, Your Honor.
He has been 8.1. Okay. Well, regrettably, Mr. Jones, your case hasn't gotten processed. Does he have a bond there at the jail?
Yeah, 50,000.
All right.
We-
Mr. Jones, you went before a judge to be informed of why you're being held, and
Yes, sir.
well, do you have any questions about your status there in the jail?
No, sir.
Okay. You're being held on probable cause for multiple offenses, the most serious of which is what I found to be a very irresponsible fleeing in a vehicle incident, and your bond is set at $50,000 because of that.
Yes, sir.
So that's your status at this time. I'm setting you down to reappear in front of Judge Putman on April 25th. Your case has not been assigned to a one of the two circuit judges at this point because the warrant hasn't been returned. It may end up on my docket, it may end up on Judge Putman's docket, but I'm setting you down for arraignment in front of Judge Putman on a week from today on April 25th.
Can I plead guilty now?
Your Honor, he has been appointed on us, but we do not have a case number, as the court's already discussed. I don't want him saying anything more. Your Honor, this appears to be very close to the two previous cases the court had called, high-speed sort of allegation. I would ask that his bond be set at no higher than $10,000, which I believe is what you set on the latter Pollard.
Well, Mr. Cooper, my remarks made in court, open court earlier, were primarily generated by reading this affidavit, which I found horrendous in its factual allegations against Mr. Jones, and the irresponsible manner of operating the vehicle, the danger to the public of someone who would, engage in this type of thing. I know I was commenting earlier on a different Chase situation, but I'm the one who set the $50,000 bond in this case, and I did so because I felt that this person, if released, having acted so irresponsibly, if in fact those facts are true, it poses a significant danger to the public. Now, so I'm not going to reduce the bond. I will respond to your request in that way.
Thank you, Your Honor.
I make no judgment at this time on his guilt or innocence. I just simply say that the number of these high-speed chases I've reviewed recently causes me a great deal of concern about public safety, and so that was all I'm responding to. So, Mr. Jones, the answer to your question, can you plead guilty today? No, I wouldn't permit that at this point. You need to talk to an attorney. You need to get an attorney, talk to that attorney, discuss your options, and before you make a decision to plead guilty. If you pled guilty to these charges before me today and admitted that everything in those charges today, you could expect to go to the penitentiary if you were admitting guilt on these charges. So I think before you get sent to the jury by a judge, whichever judge is assigned to your case, you need to avail yourself of your constitutional right to an attorney and get advice from that attorney, and let an attorney work on your case to provide for your defense. Because just pleading guilty today, I'm going to tell you, if you're admitting to the facts that are in that affidavit that I read, you're in substantial jeopardy of going to the penitentiary. Again, I'm not making any decision about your guilt or innocence at this time, and I'm reserving judgment until the case is reviewed by an attorney and the defense has a chance to work on your behalf. The facts may turn out to be vastly different than what's in that affidavit, and so that's exactly why you should not plead guilty today, and at least I won't let you do that until you've had a chance to get an attorney. Have you made application to the Public Defender's Office?
Yes, Your Honor.
All right.
Yes, sir.
All right. But you're well advised to talk things over with the court-appointed public defender as soon as that appointment is made.
All right.
You may be excused.
Okay.